Welcome once again to Lehto's Law. Here's Steve Lehto.
Aaron sent me a note yesterday, said, Steve, check out the story from your good friends at Jalopnik. It involves a dealership in Michigan. You might find the story quite interesting, and I do. But there was something about it that rang a faint bell someplace way back here, not on my shelf, in the back of my head. And headline is, dealership hit with $350,000 judgment for wrongful repossession. And the thing is that number didn't ring the bell. But wrongful repos in Michigan, I have an attorney friend, actually I know a couple people, but one in particular who loves these cases. So the story is that a dealership in Ann Arbor, Michigan, tried to get a reduction in the judgment, but the judge refused. And so the reason this didn't ring the bell completely is that the trial actually happened a while ago. What hit the news recently was the judge's most recent ruling on the matter. So I'll get to that. A federal judge just upheld a $350,000 punitive damage award against a General Motors dealership in Michigan in a spot delivery and wrongful repo case. Spot delivery is where the dealership says you've been approved for financing. Sign a bunch of documents and that's your car. They call you back later and they go, oh, your financing fell through. Bring the car back. And cough up some more money or sign some more documents. And if you don't, and they come out and grab your vehicle, if they don't have the right to do that, that's a wrongful repo. Some states allow spot deliveries under certain circumstances. But in Michigan, like this situation here, it's wrong. The U.S. District Judge rejected the argument from the dealership that the award was excessive. So going back to 2020 in July, a woman made a $2,000 down payment on a 2017 Dodge Durango and applied for financing from two lenders. And the story here is coming from the Automotive News. The following day, she completed the paperwork and took delivery of the vehicle. Everything was okay for about a week, and then things went sideways. She received an adverse action notice from one of the two lenders. The suit alleges that the dealership submitted an application with different terms to a third lender without her permission. So the approval apparently never went through. So she wasn't going to take this lying down, so she refused to sign new financing documents or return the title. And that's when the dealer hired a towing company to go take back the car. And the finance manager told her the dealership was keeping her down payment to cover its expenses. So at trial, a Michigan jury found the dealership was in violation of the Fair Credit Reporting Act, the Equal Credit Opportunity Act, and several state laws, as well as conversion and improper repossession. The store fought to have the $350,000 in punitive damages reduced, but the judge refused to do so in an opinion that he issued in late July. Evidence at trial demonstrates, this is the judge writing, the reprehensibility of the store's unlawful conduct, including the plaintiff's financial vulnerability. He cited testimony that repossession of the family's only vehicle forced them to cobble together alternative transportation, including using buses, Ubers, borrowed vehicles, and eventually renting a vehicle for months so the woman could keep her job. He also summarized testimony that the way the woman was treated was not an exception or mere happenstance, but instead represented business as usual. And so I saw the list of all the people who were deposed, who gave testimony as they prepared for trial. And they deposed a whole bunch of people at the dealership. And apparently the judge, when he heard some of the testimony come out during the trial, said it appeared it was business as usual for the dealership, which had unwound other deals in the same manner. Among those was a customer who'd been harried to renegotiate financing for 15 weeks, whose credit history had been accessed 68 times, who was falsely told alternative financing had been approved, and whose vehicle was repossessed 3 months after the sale. The most damning evidence, the judge said, was undisputed evidence that dealership employees repeatedly insisted the woman surrender the Durango or sign a new loan agreement, and falsely told her the dealership still owned the vehicle and had no legal right to unwind the completed sale at its whim. They basically said, look, our hands are tied, but it's our vehicle. I hope you know why I'm laughing. It's her vehicle. So it's always lovely to see, and this again is the author of the article, Andy Kulmowitz writing, It's always lovely to see dealers having to pay up for the stuff they do, and they pull on buyers. It doesn't always happen, but we've recently covered a dealer who talked a Ford Maverick buyer into paying nearly $1,000 a month for the truck. A dealership that sold a car out from under a woman who brought it in for repairs, and a dealer that was sued for taking back a man's new car just 2 weeks after he bought it. And yeah, it's rough out there. And so I called up my friend, Ian, and I said, hey, Ian, is this one of your cases? He goes, yeah, dude, we talked about this case. I said, well, the $350,000, that didn't strike me as a number I'd known. He goes, no, the numbers in the case are much larger. That's just the amount of the punitive damages portion of the award. The jury awarded her all kinds of stuff, and then the judge awarded us, the attorneys, a whole bunch of stuff also, because some of the statutes that they were suing under allowed for the recovery of attorney fees and court costs. And when you force a case like this to go to trial in federal court and it's prepared properly, it takes a bit of time and a bit of effort on the part of the attorneys. So I have in my hand the amended judgment, and this was filed in the federal court on July 31st of this year. United States District Court, Eastern District of Michigan, Southern Division, the Honorable David M. Lawson. Amended judgment. In accordance with a jury verdict returned on November 3rd, 2023, yeah, this goes back to last year, the order awarding damages and pre-judgment interest entered on February 28th of this year, and the order awarding attorney fees entered on July 31st, it is ordered and adjudged that the plaintiff shall recover from the defendant actual damages in the amount of $38,000, punitive damages in the amount of $350,000, pre-judgment interest in the amount of $6,433, attorney fees of $418,000, and litigation costs and expenses of $11,212. The total judgment amount is $824,641.26. So I'm not faulting Jalopnik because the $350,000 is extremely important. That's the number of the punitive damages award that the jury decided on. So at trial, the plaintiffs put on the whole case and said, here are all the laws they broke, here's how those laws work, and here's what you can award under these laws if you find in favor of the plaintiff. They found in favor of her, obviously. And so they awarded actual damages, the out-of-pocket damages that you can blackboard, as they say, $38,000, right? And then they said punitive damages, because some of the statutes, at least one of them, but allowed for punitive damages. And they said that's $350,000. Now, I don't know how they got that number, and I'm not sure if anybody knows other than the jurors themselves, but it does look sort of like it's close to 10 times the actual damages of 38. Not exactly, but close. But we don't know. And so what happened most recently was the attorneys for the dealership went to court and said, look, actual damages and attorney fees, whatever, but the $350,000 in punitive damages is too much. And a lot of times you'll see judges knock those numbers down. But the opinion here, the judge reminded the defense attorneys of some of the aspects of their case which didn't look good for them. And keep in mind, when a jury comes back and gives the plaintiff all of this stuff after hearing this testimony, it means they probably believed the testimony. And that's one of the things that's really hard to do on appeal, is to say, well, you know something, one person testified to this, one person testified to this, we think this is correct. Well, the jury thought that was correct. The jury's the one that counts. Now, obviously, if a jury were to go completely nuts and like award money to the wrong person or something, you know, like somebody who's not a party to the case or something, I'm just making stuff up here. Yeah, you could revisit that. But here, the judge said, look, there was ample evidence, testimony and otherwise, that really, really bad things happened. And they happened to the plaintiff, and they're caused by the defendant. So I'm going to let that stand. So the full judgment they were hit with, again, I'm going to knock off the last numbers to make it easier to remember, $824,000. $824,000. So as I mentioned, the trial itself took place in November, and the order awarding damages and prejudgment interest was entered on February 28th. And then there was a tussle over attorney fees, and that got resolved July 31st, and that was the occasion of the issuing of this order. And so that got picked up by the Automotive News. Jalopnik saw it, wrote a great article, got that in front of a lot of people who otherwise wouldn't have seen it. The Automotive News is more of an industry paper in southeastern Michigan. I've known about them for a long time because they've written about some of my cases. But this is not my case, but I was familiar with it. And like I said, it rang a bell. So, Aaron, thanks for sending that. Andy Kulmowitz wrote that for Jalopnik. Dealership hit with $350,000 judgment for wrongful repo, but the $350,000 is actually just the punitive damages portion. The entire case, judgment, $824,641.26. Don't forget the 26 cents. Questions or comments, put them below. Let's talk to you later. Bye-bye.
Thank you for watching Lehto's Law. We are who we choose to be.